All right, I think we're live. Hey, everybody. Welcome to Lawfare Live, a special, unusually chaotic edition. We may be recording the Lawfare podcast. We may not be recording the Lawfare podcast, but we wanted to give you the usual Lawfare, particularly neurotically thorough account of what happened in court today. We happen to have somebody right here who is unusually well positioned to give you the neurotically detailed version of what happened today. So we're just going to jump into it. I am here with Anna Bauer and, of course, Quinta Jurecic, and we are going to debrief Anna live on what happened today at the Trump arraignment. We will be taking audience questions later. As always, if you have a question, you can add it to the Q&A. The estimable Anna Hickey will invite you to speak. If this is gibberish to you because you are watching on YouTube, I'm afraid you guys don't get to ask questions, for which I apologize. But if you become a material supporter of Lawfare at lawfaremedia.org/support, then you can join the Zoom conversation and actually have your questions answered as well. All right, we're going to get started. Anna Bauer, what happened?
Trump was arraigned.
Did he plead guilty?
Spoiler alert, he entered a plea of not guilty. Who could have assumed that that would be the outcome today? No, but Trump was arraigned on charges related to attempts to overthrow a democratic election. It was an interesting day, but I don't think that anything, the last arraignment that I went to in Miami, I think that it was a little bit more spicy than your typical arraignment because there was some squabbling over the conditions of release, and they had these agreed upon kind of conditions, and then the judge decided to implement some extra conditions, and so there was a little bit more kind of substance to what occurred. But today it was a little bit more a regular old arraignment, in the sense that Trump entered the room. They went through the kind of, I'm going to inform you of a roadmap of, what the charges are, and whether or not you understand the indictment, whether you've been informed of your rights, such as the right to counsel and your rights to remain silent and not speak to law enforcement and that kind of thing. So, there was a little bit of that, which is the kind of typical, arraignment procedure. And then, Trump entered his plea, and we got to the conditions of release, which again, at the Miami arraignment was kind of the meat of the proceeding. And here, it turns out that beforehand, Trump's team had agreed with the government to the conditions, and the judge did not, bat an eye at that or kind of challenge that at all. And it was essentially kind of the same conditions that apply in the Mar-a-Lago case. So things like, anyone who they might think or that Trump might have reason to believe could be a witness in the case, he's not to speak with them about the case unless it's through counsel, and then the regular kind of arraignment conditions of, you have to appear to court, you can't commit any more state or federal crimes. And so all of those things, they went through that procedure. And then I think we'll get into it, and maybe I'll pause there, but there was a kind of discussion at the end over when they're going to put forward an estimated trial date. So maybe I'll pause there, and if you guys have any comments, but then we can get into that.
Quinta, jump in anytime.
I mean, I want to hear about your experience waiting in line, but I think we should probably get to the substance
first.
No,
we got to eat the spinach first. All right, so a couple of sort of meat and potatoes arraignment questions. Is there a next scheduled hearing date?
Yes. So that was one of the questions that the magistrate judge had for Trump's team and for the special counsel's office. She said that she'd consulted with the judge who will be presiding over the case through the pretrial and trial period, because again, this was just a magistrate judge who's kind of overseeing the arraignment, and then it'll move to the presiding judge.
So this was not, I mean, Judge Chutkan did not show up today.
No. And however, the magistrate judge said that she did consult with Judge Chutkan and said that, they talked about setting an initial hearing date. There were 3 dates that the court proposed. So that was August 21st at 10 a.m., August 22nd at 10 a.m., or August 28th. And so then she asked both sides, who government, what do you say? And then Trump's team, what do you say? And it was kind of a light and kind of comical moment almost, because of course the special counsel's office said, we can go on any of these days. And then immediately Trump's team stood up and said, we'd like the August 28th hearing.
Right, as late as possible.
Exactly. The purpose of that hearing, the magistrate judge said one of the purposes is to kind of set a schedule or a tentative kind of preliminary schedule. And as a result, she ordered the parties to, within 7 days, the government is to say when they would like to go to trial and how long they think the trial will take. And then within 7 days after that, Trump's team is supposed to respond. And John Lauro, who was Trump's attorney, who was representing him there, he really pushed back on this several times about this idea of like, we need to go ahead and propose a date, because their argument, though, which is similar to the argument they've made in the Mar-a-Lago case, it's that, there's going to be a lot of evidence in this case. There's going to be so much discovery to slog through, and we just can't possibly set a date until we know how much discovery there is. And so they kind of made this argument and tried to convince the judge to not, force them to go ahead and propose a tentative trial date. But the judge, said you can take that up with the district court judge, and I'm going to go ahead and enter the order and ask you to do, what I've previously ordered in terms of setting a date.
And so the order to propose trial dates is due when? When do they have to say when they think the trial should be? In 2098.
Yeah. So my understanding is that it was the government's proposal is due 7 days from now. So 7 days from today. And then the response from the defense would be 7 days after that. So within about 14 days, that proposal. And then it was said by the magistrate judge that at that August 28th hearing, they would have an initial trial date set.
All right. Next subject. Who is at the defense table for Trump? What do we know about the composition of Trump's defense team for this case?
Right. So at the defense table, it was John Lauro, who was kind of more recently added to the January 6th defense team. We also had Todd Blanche, who is becoming a fixture within Trump criminal cases. He not only is on the New York case that has been brought by Alvin Bragg related to falsification of business records, but he also has been involved in the Mar-a-Lago case. So Todd Blanche was there as well. And it seemed to me that although Trump kind of leaned over and spoke the most to Blanche, it seemed like he was really conversing with him a lot. Lauro was the one today who was taking the reins and was doing kind of all the argumentation before the judge. But also, surprisingly, or maybe not because of recent reporting that he stayed on this case, Evan Corcoran, who, we believe to be a crucial potential witness in the Mar-a-Lago case, who ended up having to kind of take himself off of that case because of some of the potential, conflict issues that resulted from Corcoran being compelled to testify and provide evidence regarding the Mar-a-Lago investigation. He showed up in court and he did not sit at the counsel's table, but he was there, and he, took his seat kind of next to the counsel's table.
Whoa. So Evan Corcoran, who is a prosecution witness against Trump in the Mar-a-Lago case, maybe like the key witness with respect to all kinds of obstruction. Do we know if he is part of the team or if he's just like team adjacent? Is he actively representing Trump in this case?
So my understanding,
and has anybody reported that?
It had. So there has been recent reporting. I can't tell you who it was. I can't quite recall, and I don't want to get it wrong, but I believe the phrasing was something like, Evan Corcoran has been quietly advising Trump's January 6th defense, even as he has recused himself from the Mar-a-Lago documents case. So I think it has been reported several days ago, potentially in advance of this appearance.
I had missed that.
Yeah. So, but it was shocking kind of to see Evan Corcoran walk in the room, because we might see him walk in the room as a witness in another case.
I just want to say that I'm not giving anybody legal advice, but here's some good legal advice. If you are the subject of a criminal investigation and you engage your lawyer in a fashion that causes that lawyer to testify against you under the crime fraud exception, best practices is not to use the same lawyer in a different case at the same time.
I mean, in all seriousness, I do wonder if this says something about Trump's difficulty in finding counsel. We know that he was having a tough time finding folks to represent him in the Mar-a-Lago case, I think because of a combination of, it's very high profile. He's known to be a difficult client. He's also known for not paying his bills. And so, I mean, maybe this is stubbornness on his part, or Corcoran's part. Maybe he doesn't want to part ways with someone who he feels is loyal to him. But I also wonder if it's just that, he doesn't have lawyers banging down the door to represent him, and he kind of needs to hold on to the folks that he's got.
Yeah, it's super weird, though, to think of somebody as loyal who is a prosecution witness in the other criminal case.
Yeah, that I cannot explain.
All right. So we had Blanche and Laura at the prosecution table. Blanche seems to be the Trump whisperer. Laura,
yeah. So and Blanche seemed to literally be the Trump whisperer, because he was whispering to Trump. They spent about 20 minutes, and I will say, Trump very much had to wait around in court. Something that was very different today is that we entered the courtroom. So in Miami, when we entered the courtroom, Trump was already there. It was, completely, hushed in the courtroom and very solemn. And then today we entered the courtroom, I want to say like 2 hours in advance. I should mention that they would not let you leave to go to the bathroom after you're in there. So we're all just trying. So everyone in the media gallery was like, they were like, oh, should we go write our pieces or like go to the bathroom first? Because we're in there for several hours. But so we enter the courtroom here very far in advance. Trump is not there yet. And it's all kind of a little bit more, chill and I don't know how to describe it, relaxed, I guess, because by now it's the third arraignment in. And so everyone's a little bit used to it.
It's like a weekly party now.
Right. But so Trump enters and he is sitting there for a good 20 minutes waiting for the magistrate judge. And the whole time he's, whispering intently with Blanche. At one point, he picks up a thick document that we think is the indictment. And he's kind of like, gesturing at it and pointing. And he seemed a little bit less glum and a little bit more kind of excitable or kind of even angry or animated than he has been at previous hearings. But I'm assuming your next question for me is going to be who was sitting at the prosecution.
Yeah. And I noticed, so last time you did this incredible story about the stair.
Yeah. Oh, right.
And nobody else reported the stair last time.
I think
This time, everybody's talking about Jack Smith didn't lift his head when Trump came in, but then they were staring at each other. So we want the story, the eye contact story,
right
from the OG eye contact describer.
Right. Okay, so Jack Smith enters and he sits down. He's not sitting at the counsel's table. He's sitting kind of at the same, on a different side where Corcoran was sitting, but, you know, kind of right behind where the other prosecutors are sitting. And I should mention the other prosecutors who actually did make appearances and spoke at the hearing. It was Molly Gaston, who has been associated with the January 6th investigation, and she's also had a lot of experience in other January 6th cases. She was the one who handed up the indictment whenever it was handed up before the magistrate judge earlier this week. And then the other person who kind of, again, took the lead and did all the talking was Thomas Wyndham, who is known to be kind of the lead prosecutor on Jack Smith's January 6th probe. But so Smith is sitting there, he's sitting maybe, 10, 15 feet from Trump. And unlike last time, where Trump's, back is to Jack Smith, they have a very clear view of each other where, if one of them turns their head, they're just like looking right at each other. And it appeared that Jack Smith, did look over at Trump quite a lot. At one point, they appeared to make eye contact as both of them were kind of scanning the room, and they look at each other. And a reporter next to me, because of the whole stare, he's like, they just made eye contact. And so
the romance continues.
Exactly. The rom-com continues. But so I think though that there was maybe a concerted effort on Jack Smith's part to not make a big kind of drama of when Trump's leaving and exiting the room. As soon as Trump got up and left, Smith he was looking in the other direction, and he got up and, unlike last time where he just exited, he stood around and spoke to some folks who, one of them I think might have been an FBI agent. They were kind of joking around, and it was a kind of rare moment of seeing Jack Smith, who is this very, stoic, has this very stoic public persona. He was smiling, he was laughing, and seemed to be very much at ease for a few short minutes at least.
Quinta, do you have more in-court questions before we get to the super all-important line issues?
I'm relieved to hear that Jack Smith was smiling, because someone on Blue Sky compared him to looking like a World War I poet who, was shot to death with an anti-war poem in his coat pocket. So he does have, the haunted eyes of an ICTY prosecutor.
Yeah. But he seemed like he was having a good time. He did not have those vibes today, Quinta.
Good for him. I mean, so I think it's worth noting, Ben, correct me if I'm wrong, I think Thomas Wyndham has actually been on this case longer than Jack Smith has.
Correct.
He's been on it since the very, very beginning. And there was a bunch of reporting actually about how he was kind of the guy pushing DOJ to move faster.
Yeah, so I don't think it's right that he was on it from the very beginning. I think he was brought in at the time at which they decided to what they thought it needed a shakeup and an injection, and they brought in Tom Wyndham at that point, I believe, but somebody should check me on that. All right. So who was Wyndham and Smith the only people from the special counsel's office, or were there others?
I believe that there was, I think it's Ray Holster. Does that ring a bell?
No.
Or Ray Holster. That is who we members of the press corps, we think that is who that was. His face was kind of turned away for much of the proceeding, but I can't speak to much about him other than that's who we believe it was. So I think that kind of, Peter Carr, the public relations guy was in the audience, and there were some other folks that I recognize. There was a woman who does some of the security for his special counsel's office. So, but other than that, I think that's who was worth mentioning. But something that was very surprising and interesting that I don't know has been reported, because I know that there's other things that folks probably felt was more important, but I found it really interesting. Around 3:40, a kind of stream of folks enter the room, and they take up the entire last row on the left side of the courtroom. And it's about it's 3 district court judges and 2 magistrate judges.
Whoa.
And I think it was the district court. I'm not sure about the magistrate judges, but the district court judges, it was Chief Judge Boasberg. It was Judge Amy Berman Jackson and Judge Randy Moss.
Wow.
And I believe Judge Boasberg had his son with him as well. That's who we think he was with. So it was very interesting because I have never seen something in a courtroom.
Judges do not usually hang out in each other's courtrooms for spectator sport reasons.
And, interesting, there are a few Trump appointees on the District of Columbia District Court. None of them made appearances. There, in the jury box, there was a lot of clerks who were there watching. To be honest, I think that maybe half the audience was made up of just court staff, as opposed to, members of the public and media. As in terms of members of the public, there was only 5 people in the in-person courtroom. One of them was a 16-year-old and his mother, and the 16-year-old just wanted to go. And so his mom said, okay, I'll go with you.
That's awesome.
Yeah. Another guy was like a guy who'd been a line sitter and I guess just decided to hang around. Another guy was just someone who was in his 20s. He wanted to be there. And then the last one was a former journalist who I guess wanted to kind of be back in the room where it happens. So that's kind of who showed up. But the most interesting thing to me was the appearance of the judges, because you don't see that.
Yeah, you really, and these are 3, the chief judge of the court, Randolph Moss, the one of the others is a judge who used to be the head of OLC at the Justice Department. He's an extremely well-regarded lawyer and judge. And Amy Berman Jackson has the Pete Strzok, Lisa Page case currently. So these are
and had a lot of the Mueller cases as well. She was, for some reason, her name kept coming up.
And they all have, of course, as all the district judges here do, a lot of January 6th cases. So these are, it's super interesting that they showed up for an arraignment. All right. I think we are ready to go to line talk.
We've eaten our vegetables. Now it's time for dessert.
Yeah. So when did you get there? Were you first in line? And did you spend the night there?
So I showed up around 12 to 12:30, I think. And my plan was actually not
12 to 12:30 last night.
Oh, right. The day before.
Yesterday.
Yeah. So
the hearing is at 4:00 on Thursday, and I show up at 12 to 12:30 on Wednesday.
Yeah. You're nuts.
Yeah, I know. It's crazy. But Ben, we talked, and my plan, you can confirm, was not to get in line. It was to go to the courthouse and scope out whether or not a line would be forming at some point soon.
As with quantum mechanics, observing the line causes the state of the line to change.
Right. So I show up and I am hanging around looking to see, waiting in the pre-line to the line. And I hear that many of the networks have agreed to have a kind of,
Okay, wait. Breaking news. Caitlin Collins has just tweeted that the man who handed Trump his umbrella as he exited the motorcade at National Airport was none other than Walt Nauta, his co-defendant in the Mar-a-Lago case. Please continue.
Well, Nauta was not in court, but right. Wait, where was I? Oh,
The creation of the line.
the creation of the line. And so I show up, I'm waiting around. I hear that the networks have a ceasefire. They've agreed no one will start a line until 5 a.m. the morning of.
And of course, Lawfare was not party to this agreement.
Yeah, I know. We seem to never be a part of these media agreements, but so I'm thinking, okay, I'm going to go home. I'm going to sleep in my own bed, and then I'm about to leave, and I see a young man who has a kind of umbrella and a chair, and he looks like he is about to start a line. And so I make a beeline towards him and I say, "What are you doing?" and he said that he had been told by CNN to start a line at 5 p.m. And I was like, "Oh no." And then of course ABC runs over and they're like, "What are you guys doing? Are you forming a line?" and then we're like, "Great, now the line has started."
Because once people perceive the line exists. Okay, right. So the line starts around 2:30, and then Quinta Jurecic steps in and saves the day. So I was very upset that the line materialized, because this meant bad things for Anna and her capacity to get some sleep. So I was about to round up Lawfare people to spell Anna, including myself. Just want it known that I was planning to show up myself, when Quinta discovered the greatest service that has ever existed in the world. Quinta, tell us what you discovered.
Yeah, so I'm so sorry. I've forgotten their name, so I can't give them a shout out by
Though
name.
we do endorse them.
Yes, very, very strongly. I will pull this up as soon as I finish talking. There is a professional line sitting service in DC. I thought of this because some of you all might remember in Manhattan during the arraignment there of Trump, there was some reporting. The New Yorker did a sweet little profile of an organization that I think is called Same Ol' Line Dudes, LLC. Yes. So they are, as the name suggests, they will wait in line for you in New York City. And they advertise that they will wait in line for you at, museums, at concert venues, for the Magnolia Bakery. There's a special procedure if you want them to wait in line for you at the Magnolia Bakery. And I thought to myself, I wonder if this exists in DC. And it turns out that it does. And the folks who I called were able to come and stand in a line for us at very short notice. Very professional. Thank you so very much. And their website, in fact, announces that they will stand in line for you at, yes, concerts, museums, and I think the DC equivalent of the Magnolia Bakery turns out to be congressional hearings, Supreme Court oral arguments, and U.S. District Court.
Yeah. So Quinta, as soon as you look up the name of this company, we will formally endorse
it. Is
them.
Skip the Line LLC.
Yes. So
and shout out to Andrew.
Yes, who is a pro, and I think he told me he has slept outside of courthouses in DC more than 30 times.
Oh my God.
And he knew where lines form. He was like, yeah, usually they form the line going uphill that way, not this way. So they're going to move us. And they did.
This episode of the Lawfare podcast and Lawfare Live is brought to you by Line Sitter, but by Skip the Line DC. Seriously, folks, if you have to stand in line overnight, we're going to use this company over and over and over again. All right. I'm going to ask you, Anna, the most inappropriate question you have
I know what it's about.
You have ever been asked in a public setting. Was there an anti-circumcision protester at the line?
There was, and I tried to send it to our Lawfare Slack earlier, but I have some videos to show you, Ben, of the anti-circumcision protester.
And what was his slogan?
His slogan was,
we're gonna have to bleep this.
No foreskin, no peace. and save the foreskin. He repeated them over and over again.
So how long was he out there, and did the line collectively do anything about it?
But okay. So I have heard from talking to other reporters, because they were totally unfazed by this, because he was walking around chanting this over and over again. And apparently he is a regular around that area. He typically sticks around the Capitol, but I think because of everything that was going on at the courthouse, he made his way over and decided to make that his route for the day. So, but he was around, I mean, like he was around the entire time. Like whenever the line formed, he was there walking around chanting. And then, you know, today when everyone was protesting Trump or celebrating the Trump indictment or whatever their various kind of demonstrations were, he was still out there on his, you know, taken his own battle to the in front of the federal courthouse. So it was interesting.
All right. And were there other protesters as well, or was the only protests about circumcision?
No, for the most part, it was not about circumcision and all about Trump, either protesting the arraignment as, you know, unfair or unjust in some way. There were Trump supporters who were trying to, you know, say that he's innocent and all of that. And then, you know, and some of them were regulars. There is a group, I believe it's Black Americans for Trump, who I have seen at every single hearing, and they had a presence there. There were some others who were, you know, pro-Trump, but then more frequently what I saw was anti-Trump protesters or demonstrators who kind of were, you know, celebrating or kind of, you know, were basically just there to kind of counter protest against any pro-Trump protest. So but to be honest, it wasn't a huge group. It felt to me like Trump had a much more kind of MAGA crowd at the Miami arraignment than here. So yeah.
All right, so we're going to go to audience questions now. The first question from an anonymous attendee is the defendant required to be present during trial? So I'm actually going to answer that myself. The answer to that question is it's really complicated, and it very much depends on the judge. So the defendant has a right to be present, but the right can be waived. So in that sense, you would imagine that he could waive his right by not showing up. That said, you can't just not show up without some degree of leave from the judge. And so you could imagine him waiving his right to be present and saying he doesn't want to come because he wants to, you know, go to Iowa and campaign. The judge would have something to say about that and might allow it or might not. If you do waive your right to be present, you waive all kinds of things with it, like the right to appeal because you weren't there when key evidence was introduced against you. So it's actually a really complicated question, and I think different judges may handle it differently if, in fact, Trump doesn't want to sit through weeks and weeks of his own trial.
And I'm just going to add on that point because we didn't talk about this in the substantive portion of talking about the arraignment. The magistrate judge today mentioned that Trump's appearance can be waived if he would like it to be waived for that first date on August 28th. She did not make any representations about further appearances, but for that August 28th hearing, she indicated that if Trump doesn't want to be there, he doesn't have to be there.
Yeah, and I think that's since the process of going to these is, I think, a bit humiliating for him. I think it's very likely that to the extent he is excused, he will avail himself of that. All right. So a bunch of you have multiple questions. That is fine. When we invite you on, just start at the top of your questions and run through them. Again, we're going to ask for relatively brief questions and brief answers. Antti, the floor is yours. Joining from Finland in the middle of the night.
Thank you, Ben. So how were the security measures compared to the Mar-a-Lago case arraignment? What's your impression? Thank you.
You know, I felt that it was a heightened security presence, and talking to other reporters who are around the Prettyman courthouse a lot, it was very jarring for them to see the groups of court marshals, of Secret Service agents, of Metropolitan Police, all of these different law enforcement agencies who were, around the building. They felt it was very kind of jarring to see that. But for me, in terms of having been at Miami and then also here, I felt that the Miami arraignment had a more visible security presence. The day before, there was a very very much like it felt a little bit lax in terms of the security presence. I just couldn't visibly see any law enforcement around very much. That doesn't mean that they weren't preparing, but it was not like Miami where, days in advance, there was kind of a larger security presence, people patrolling. Today, in the hours before the arraignment, I took a stroll around the courthouse, and it seemed like the police were kind of feeling a little bit relaxed about the situation. They were standing in groups, chatting, whereas in Miami, things just felt more tense. That might have been because it was the first federal indictment. It might have been because it's Miami and in Florida, where Trump has a lot of supporters. It might have been because the security situation there, from talking to DHS people and law enforcement on the ground there, they were concerned about the height differences in the buildings and things like that. So I think they had reason to kind of worry there. But at the Prettyman courthouse, they have a little bit more experience with high profile cases. So that could also explain why maybe it felt a little bit more minimal.
There's also, I think it's worth underlining in terms of the security presence. So for people who haven't been to DC or spent time at the courthouse, it's literally down the street from the Capitol. You can see them from one another. It's maybe like a 5-minute walk. It is down the block, which is, striking insofar as it means that Trump is being tried in the courthouse for attempting to invade the Capitol, which is right down the street. But it also certainly made me a little nervous in terms of the security situation, because this whole trial is about how that other building right there was stormed by angry Trump supporters. And in fact, just yesterday, there was a bit of a scare at the Capitol on the Senate side, where Capitol Police received what seems to have been a fake or misinformed call about an active shooter that caused a lot of congressional staffers to have to shelter in place or be evacuated from buildings. It turned out that everything was fine, but I think folks were very much on edge, and there was some good reporting in Time magazine this morning about how for a lot of staffers that really brought up memories of January 6th and having to shelter there. So all of which is to say, I'm interested to hear that the security presence was seemingly lax or not lax, I guess, depending on your perspective.
It's relative to what happened in Miami, right? Yeah. And but I do just want to say on really quickly, so I'm sorry to drag this out, but Quinta, your point is so on point in terms of the being in the shadow of the Capitol. Kind of, it was very interesting to be in the cafeteria at the Prettyman courthouse, and you can see the Capitol.
Yeah, and there's a nice view.
Yeah, and it's like a reporter I sat down to lunch with, he said, "Isn't it so weird how we literally have the scene of the crime right there?" And it's just really, and there in the same cafeteria was Nicole Ruffett. Is it Ruffett or Refit? Does anyone know? Okay, so Nicole Ruffett, who is the wife of Guy Ruffett, who was one of the January 6th defendants, who was the first January 6th defendant who went to trial, as I understand it. And you know, she's sitting there in the cafeteria. We have the Capitol kind of right there, and it all just felt very kind of, you know, even though this is the third arraignment that Trump has been through, there's something about having it in this courthouse where there is that location, you know, there is that history of all these January 6th defendants who have been through, and then, you know, now the person who to some extent, you know, these alleged crimes relate to, you know, the events of January 6th. And so it all just felt quite fitting, I think.
All right. So that was a model of brevity in the
Sorry.
formulation of the question
Sorry.
and not so much
I
in the
know.
answer. Brody, the floor is yours.
Yeah, hi. It's clear that already the MAGA universe has decided to begin to attack not only the venue but also the judge assigned, and as I understand it, you know, personal bias or prejudice can't normally be ordinarily be based on judicial rulings or upon a judge's opinion on trial evidence or at trial. Has Judge Chukon made any statement outside of the cases that she's been involved in that could be a basis for bias or prejudice?
I am unaware of any. She is by reputation one of the tougher sentencers in January 6th cases, but those are all judicial rulings. She is also by background a public defender and certainly has a, you know, is not thought of as a sort of blindly pro-prosecution judge by any means. And then, I mean, my sense of her is principally conditioned, at least outside of this arena. I mean, she wrote a very famous ruling in one of the January 6th cases. And she also, in my opinion, grossly mishandled a habeas case during the Trump administration, a case called Doe v. Mattis, which was notable not for the substance of what she ruled, but for the fact that she didn't rule for months and months and months in a fashion that I thought was very inappropriate, actually. But I don't know of any out-of-court statements that she has made that would be at all, actually, much less any that would be considered prejudicial. I'm sure Trump's lawyers will find any such statements if there are any. But by the way, it's not clear to me. I mean, I think Judge Chutkan is a bad pick for Trump if it gets to sentencing, but I'm not sure that she doesn't, I don't think, have a reputation for having been unfair procedurally to January 6th defendants. So I don't think you're dealing with a situation in which you know, she's not one of the more mercurial judges or on that court. All right, John B., the floor is yours.
Thank you. Fulton County District Attorney Fannie Willis has been in the news talking about offering some comments that she's not coordinating at all with Jack Smith, either in terms of substance or calendars. And I'd like to get the team's reflections on the implications for that. And the second question is related, which is, does Smith have the authority to enforce his calendar over whatever timeline she's putting together? Thanks.
All right, so I'm sure we all have thoughts about the calendar issue. Anna, why don't you get started with it?
So I guess that in terms of thoughts about coordinating, I think that I have said before, and I think that I still stand by this now, that I'm not entirely sure to what extent it would be appropriate to some extent for them to coordinate. insofar as it involves, potential grand jury material or that kind of thing. There's in the federal rules, there's these grand jury secrecy rules, and there's not an exception that allows for, transmitting grand jury material to a state prosecutor. So there might be some concerns over to what extent, coordination over the substance of a case would kind of, get into potentially violating some of those rules. So that might be a concern. But I don't think there's any public signs that they are coordinating, whether that is in terms of overlapping substance or the calendar. Fani Willis has said, like, I don't know Jack Smith. I think the quote was, I don't think he'd even know how to pronounce my name. I've never talked to that man.
I wouldn't recognize him.
I wouldn't recognize him if I saw him on the street, Oh, sorry, Ben.
No, I particularly liked and I'm sure he wouldn't know how to pronounce my name.
It was good. A classic Fani Willis quote. But so I think it's clear that it seems like they're not coordinating. Whether that means that Fani Willis doesn't, realize just as a practical matter that, it's not a bad idea to piggyback off of a federal case if you're building a racketeering RICO conspiracy case in Georgia, because some of those federal crimes can be predicate acts under that statute. And I think that, she might have that in the back of her mind. And this kind of supercharges her case to some extent because she can now kind of follow the Fed's leads in terms of, what they've written out in the indictment if it doesn't, totally overlap in substance with what she has discovered in the course of her investigation. Calendar's Ben, I'll throw it over to you because I'm being too long-winded again.
That was not too long-winded at all. Quinta, do you have calendar thoughts?
Nothing to add to that.
All right. So I am going to say about calendars the following. First of all, the issue of how you coordinate multiple state and federal jurisdictions, all with concurrent prosecutions, can be a complicated one. The case that I know that on this issue looks most like this is the case of the DC sniper, John Allen Muhammad. I don't mean to compare their crimes by any means, but Muhammad had, as I recall, pending criminal charges in Alabama, Maryland, DC, Virginia, all at the same time. There may have been one in Washington state as well. And everybody wanted to go to trial and they really fought over it. And I think eventually you have to, judges and prosecutors have to put their heads together and kind of make responsible scheduling decisions in consultation with one another. This is ultimately going to require some people to be grown-ups, and the good news is that the two biggest cases here are both being handled by the same prosecutor, so he will not propose dates that conflict with himself. John H., the floor is yours.
Oh, hi, Ben. This is, of course, merely just a comment and not really a question, but I do think there's an entire closet industry of line standing services in DC, and we often hear about it in the Supreme Court context. In fact, I think they're barred from the Supreme Court bar line. In fact, if you want to sort of go into the weeds, it's a little dangerous to praise the line standing services because, of course, they make it easy to stand in line, and that's what leads to lines starting sooner than they ought to. So I think there's a hard game theoretic, what's the Nash equilibrium question to think about?
I think this is an extraordinarily important point. And I will just say that Lawfare is going to participate in making this problem worse so that Anna can get more sleep. And I understand that when we do that, we are actually not we're not approaching it from an optimal game theoretical point of view. But I'm afraid this is one of the that's going to be a tragedy of the commons situation.
I'll just say, as a resident of Princeton, New Jersey growing up, I appreciated the John Nash shout out.
All right. Michael B., you have some questions.
The big question, and I suppose unknowable, is how likely is this case to actually make it to trial?
Totally unknowable, but I would say if Trump does not get elected president, it's extremely likely to go to trial. If Trump does get elected president, it's extremely unlikely to go to trial. So
Sure.
if you can tell me what the likelihood of Trump's election is, I can tell you the answer to your question. But absent that, I don't think anybody can.
Fair enough. So my other question is just a boring and hopefully simple process question. If a defendant voluntarily surrenders, does that constitute an arrest?
The answer is no. The arrest is when you are stopped. Arrest literally means stop and taken into custody. When you surrender yourself to custody, he was in custody. He presented himself and was presented before a magistrate and was then released on his personal recognizance. But that point of time, he is in custody. He's just not the subject of an arrest. He surrendered to custody. Justin S., the floor is yours.
Twofold question you answered a little bit already there, Ben. The first part is, are Trump's current crop of lawyers competent enough to actually argue that his previous lawyers are incompetent? That seems like a bit of an uphill battle, and they're not starting from a strong place, given that they keep going and making problematic statements. I know the media is not a jury, but somewhat problematic, I think.
So do either of you have thoughts on this?
So I guess if I understand the question, the question is whether Trump can make an advice of counsel defense and basically argue, he was pursuing what was functionally a coup, but he was doing it on the advice of his lawyers and they gave him bad advice. It's an interesting question. I'm sure he'll try it. I think there was some reporting in Rolling Stone to that effect regarding John Eastman. I think the problem that it runs into is that those lawyers themselves are in some instances on record as essentially saying, yeah, I'm just making this up as I go along. Eastman never said that. I'm extrapolating a little bit here, but there's, he on one day makes one argument and says, well, I'm making argument X because argument Y would be crazy. And then the next day comes back and says, great news, we're going to go with Y. That's been right. And it's right all along. So that doesn't look great. And I believe that it is actually one of the issues about which Eastman is currently facing ethics trial in California, pursued by the California bar. So given that, I don't know about the specifics of how an advice of counsel defense would function, but that makes me think that there are some pretty gaping holes in it. Also because he was told by plenty of other lawyers, including the White House counsel, the deputy White House counsel, campaign lawyers, etc., you lost, you need to let this go. And he essentially chose to listen to the lawyers who were making the crazy arguments.
I also will say that the Trump's attorneys on this case who made appearances today, John Lauro and Todd Blanche, my understanding of both of them is that they both have very good reputations amongst their respective legal communities. Todd Blanche in New York and John Lauro in DC. And does he practice elsewhere outside of DC?
I don't know, but he's here.
But yes, and so I mean, those two I have heard are very good. I also will say in terms of a potential Fulton County indictment and where there's maybe overlap in terms of defenses, Drew Fendling, who is Trump's Fulton County attorney, also has a very good reputation, like just overwhelmingly praised within the criminal defense and criminal law bar in Georgia. And so he does have some reputable attorneys on his team. Wouldn't it be the first time that an attorney has joined Trump's team with a with a good reputation and then maybe has ended up with not as good of one? But that remains to be seen. And what I've seen them do in court It's not anything crazy yet. So to be determined about, what they end up doing, but we'll see.
Yeah, I will just say, first of all, the fact that lawyers make ridiculous arguments does not necessarily make them bad lawyers. Sometimes you have to make ridiculous arguments because you're ethically required to make any argument that could conceivably help your client if you can make it ethically. And so people make stupid arguments all the time, and that's not necessarily because they're stupid people or incapable people. The other thing about the advice, there's another problem with the advice of counsel defense in addition to the ones that Quinta mentioned, which is I don't know how you make it without Trump testifying. And I'm not sure that it's an easy argument it's a very easy argument to present in the court of public opinion, where you can anonymous people close to Trump can kind of whisper it in the ears of journalists. But how do you actually make it before a jury if you don't have the former president take the stand and testify that that's why he did it? I cannot promise you many things about this trial. I can promise you that Donald Trump will not take the stand in his own defense. So there may be a way to make this defense anyway, but I'm not sure I quite see how to do it. All right, we got 3 more questions. We're going to move through them. Anonymous attendee has 2 questions. Where do things stand regarding Trump shooting his mouth off and incurring a contempt citation? Is he being given a long leash, so to speak? What sanctions are realistically available? Well, so the answer is the place where this question is most relevant so far is New York, where he has attacked the prosecutors, attacked the judge, and he has not yet incurred a contempt citation, or I think a motion for a contempt citation. So I think the answer is he is so far being given a pretty long leash. And that leads us to the second question, I think by the same anonymous attendee. How much deference do you anticipate will be given to Trump's campaign appearances? I think the answer to that question is probably a bit. And the question of whether that means that he will be allowed to not show up for parts of the trial, or whether there will be some date after which you do not schedule a trial because he's the Republican nominee for president, or will be at that point. I'm not sure how it will show up, but I think you can expect that there will be at least some deference to the fact that he is running a presidential campaign. Okay, Julie, you get the last question today. Julia, you got to unmute yourself.
There you go. Sorry. I heard Ben opine with Charlie Sykes today on their joint podcast about televising the trial. Ben, you didn't care for the idea. I know you didn't care for the idea. And I'd like to you did say that you were concerned about cameras being on witnesses for hours every day and potential attacks on them. But haven't there been other trials where the jury was not shown, witnesses were not shown? I think who was it, South Carolina lawyer that killed his wife and son? That was televised, but you didn't see the jury or the witnesses, as I recall. So can you address that about? Yeah. And I know that the judicial conference, is against it, but Neil Katyal tweeted this morning that Roberts has the power to do it himself.
Yeah. So, I want to distinguish between appellate law and trial courts here. And Neil is an appellate lawyer, very good one, but he's an appellate lawyer. And when you have an appellate, when you practice appellate law, the record is fixed and you don't have witnesses, you don't have jurors. The other day, Anna was down in Fulton County Court for the opening of the grand jury session. And she was allowed to sit there and look at the grand jurors. I think that's insane. And if we had had and if she'd had a video camera there, she could have taken video of the entire proceeding, except including showing the faces of the jurors.
So we weren't allowed to photograph the jurors or video them, but we could, report things out about them that was, revealed. We knew their last names, but no one reported that. We now know all the names of the grand jurors because they're on every indictment in Fulton County. But no one's been reporting that. But yes, Ben, it's kind of crazy because you don't ever get access to grand jury proceedings like that.
Yeah, and I think it is one thing to ask people to come in and in the dark of a grand jury room to discuss, or a jury room to discuss the fate of the former president, who has tens of millions of supporters all over the country, some of whom are more than capable of sending extremely threatening messages to people. And I've received some of these. It's quite another thing to ask them to do that and then, expose their names to the public, expose their faces to the public, because, somebody is going to be less responsible than Anna. We discussed how to, when we got the transcript, by the way, has all their names in it. We discussed how to describe the proceeding without including names. But, somebody's not going to bother to do that. And if you televise the proceedings, okay, so maybe you don't show Cassidy Hutchinson's face, but you hear her voice for hours and hours and hours, and I just think it's one thing. It's very easy to say, and by the way, in state courts, you're not generally dealing with a national audience. You're often dealing with no audience or a very local audience. And when you have cases like that South Carolina case or the O.J. Simpson case, or, the result is not wonderful.
There's also another really recent example is the trial. I'm not sure which jurisdiction it was in. I think California, maybe New York, the Johnny Depp Amber Heard sort of cross defamation trial. There's a really excellent essay in Slate by Rennell Anderson-Jones and Larissa Lidsky, who are both law professors who read about the First Amendment and who are following it closely, about how the fact that the trial was live streamed essentially created just this complete zoo of informational chaos online because people were watching, they were pulling clips without context. It seems to have contributed to a lot of false information circulating about Amber Heard and demonizing her, attacking her by Depp's fans on TikTok and other platforms. And Lidsky and Anderson-Jones sort of conclude that this is actually a case where it seems like, giving the public access to legal proceedings didn't actually improve the public sense of the case. So that's obviously, it's a defamation trial. The scenario is very different, but I do think that I'm generally someone who believes that, court proceedings should be more open to the public than they are. I think that case gave me a lot of pause. And the O.J. Simpson trial obviously is another excellent example of how this can go really, really wrong.
I am all for cases being very open to the public. I think you have to be careful when you're talking about compelling witnesses to be on television. And I just think I know it's the norm in a lot of states, and I don't know how, as a court official or a prosecutor, I would say not merely is it your civic duty to show up and testify, but it's your civic duty to become an international celebrity by showing up and testifying. That's not what people sign up for. All right. We have gotten through all the questions, and we are going to leave it there. folks who are watching on YouTube, join the conversation, become a material supporter of Lawfare, and you can join and have your questions answered too in the future. Do that at lawfaremedia.org/support. And to everybody who joined either on YouTube or on Zoom, thanks for joining us. We will, as Charlie Sykes would say, we'll be back and we'll do it all